There are typical questions that are asked about the collaborative law process. In the next few minutes, I'm going to try to address some of those questions. One of those questions is how to begin the process. A couple must first determine if they are proper candidates for a collaborative divorce. Both must genuinely want to resolve their marital breakup in a negotiated way, and both must be willing to compromise. If children are involved, then the parents must both have somewhat similar objectives in mind on the issue of time sharing with the children. Both parties must either know the family finances or be willing to fully share their knowledge with the other side. Both must be willing to make full financial disclosure, both in paperwork form and verbally. And lastly, both parties must be willing to pay for the cost of a collaborative divorce. While the cost may be more than a single mediated negotiation session, it is typically considerably less than contested litigation. The second step is to choose the appropriate attorneys. Most family law attorneys that practice collaborative law are a member of one of the two Tampa Bay area collaborative law groups. I am a member of the Next Generation Divorce Group, which was, until recently, known as the Collaborative Divorce Institute of Tampa Bay. Oftentimes, one spouse finds a single collaborative law attorney who then provides a list of other collaborative law attorneys in the area who can be available to the other party. The third step is to pick a collaborative law team. The two attorneys are part of the team. There is typically also a mental health professional and a financial professional. Mental health professionals can include minor child time-sharing specialists if necessary, and financial professionals can include either an accountant or financial advisor. A team can be either smaller or larger than this, depending upon the complexity of the case and the divorcing couple's ability to pay. The fourth step is to sign all necessary agreements. The most important agreement is signed between the divorcing couple. Among other things, they agree to deal with each other honestly and to make full financial disclosure of all relevant facts. They also agree that if the collaborative negotiation process does not work, then all professionals involved in the process will not be involved in any contested litigation which may follow. The attorneys also sign this agreement, which, in part, requires that they will both withdraw should the collaborative process fail. Other retained experts sign a similar pledge. The costs associated with each professional involved in the case are also detailed in the agreements. The fifth step in the process is to exchange all needed documents and information. While the bulk of these exchanges take place at the beginning of the collaborative law process, the exchanges continue throughout the process as needed. The last step is to schedule your first collaborative law session. This is where the hard work begins and where progress is made. I hope that you have found this short video helpful. This website, tampadivorcenow.com, if you are not currently visiting the site, contains several other written statements and videos about the most common areas of family law in Florida. They are all logically and consistently written to maximize the flow of useful information to you as quickly as possible. Please feel free to navigate them as you feel the need. I am David Anton. I am a third-generation Tampa attorney who has predominantly practiced family law for nearly 30 years. It is not just my job or even my career, but my calling. For a thorough initial consultation, please feel free to call me at the office at 813-443-5249. Thank you, and I wish you the best in navigating your family law issues.